This woman discovered that part of her property had been advertised in her neighbor's real estate listing. Now the judge must decide whether that mistake was an oversight or an attempt to profit from property he didn't own.
Your Honor, my neighbor listed his property for sale and included a portion of my land in the listing photos and description. The advertisement clearly showed my side yard as if it were part of his parcel. I contacted the listing agent immediately.
Your Honor, I relied on the information provided by my client. He indicated that the area in question was part of his property. When the plaintiff's husband showed me a county GIS printout identifying her as the owner, I informed potential buyers of the dispute.
In addition to the listing, my neighbor planted trees across the boundary line over the past several years. Some are diseased. One is a thorn-covered tree that was planted shortly before he moved out. They sit entirely on my parcel.
Your Honor, I believe the property extended further than the stake suggests. I relied on what I understood to be the boundary when I maintained that area. There was no intent to sell land I did not own.
The listing photograph clearly shows the boundary marker. The GIS record identifies the plaintiff as the legal owner of the disputed strip. Advertising property beyond a known marker raises serious concerns. The court finds that the defendant did not have legal authority to market or represent the plaintiff's property as part of his own. Regardless of intent, the listing was inaccurate and materially misleading. The defendant is ordered to cease any representation of ownership beyond the recorded boundary and remove any plantings encroaching on the plaintiff's parcel within 30 days. If removal is not completed, the plaintiff may remove the encroachments and recover a reasonable cost.